Welcome to the Property Appraisers Continuing Education Luncheon. Today we're going to be talking about property tax laws in Florida. I'm Alex Luca. I'm the staff counsel for our office and the director of exemptions. So today we're going to kind of take a deep dive into the way that the different laws in Florida, real property laws specifically, really interact with what you end up paying on your taxes, and wrap our heads around kind of the different types of ownership that you'll see in Florida, and once again, how they're going to interact with the real property taxes that you pay. So we'll start off and we'll jump right into ownership. So this is a very important part of your property taxes, because depending on what type of ownership you have, you can claim certain exemptions or certain percentages of exemptions. So we're going to walk ourselves through, the homestead exemption. You have to have legal or beneficial title and equity to the property as of January 1st. So that's another thing we'll touch on real quick is January 1st is the golden date for the property appraiser's office and your real property taxes. We assess property as of January 1st. We look at the ownership as of January 1st. If your ownership has changed, then your property will lose all of the exemptions that may be on the property, or if you have some type of other cap on the property, it may be removed if the ownership has changed as of January 1. Below, you'll see too on the slide that ownership interest must be recorded. So the property appraiser's office, we rely on the clerk of the court's records, what's in the public record, in order to update our records for ownership. So yes, you may have a deed that gives you title to a property, but if it's not in the public record, our office doesn't know about it to assess you as the owner of the property. And also, we don't know about it in order for you to claim an exemption. So you have to have recorded title to a property in order to claim exemptions in Florida. So the different types of tenancy we'll get into in a moment, but really, what is a recorded instrument? A recorded instrument provides notice to our office, and it's something that's recorded with the clerk of the court's office. There's several different types of recorded instruments which relate to the title of the property. There's several of them below here, and we'll break down what kind of each of them mean. But if you own property in Florida, when you're sitting at the title table, you've probably seen some of these different instruments when you took title to your property. So these are all also instruments that are delivered to our office by the clerk of the court. So if you gained ownership through a less common means than a deed, our office may not know about it, even if you did record it with the clerk of the court. So these are the instruments that do not get delivered to our office by the clerk of the court. If you have a dissolution of marriage and you jointly own property together, once that divorce is finalized, the final judgment may be a public record, but our office isn't delivered those. So what the taxpayer really, you need to be proactive in providing us those documents, because sometimes a dissolution of marriage can act as a conveyance. Some of them direct one of the ex-spouses to execute a deed, but some of them do act as a conveyance once the dissolution of marriage is final. Corporate entity acquisitions, if you change the name of your corporation, or if there's a merger of some sort and it's not memorialized through a recorded deed, we're not going to know. So that will also need to be provided to our office. Trust documents. So a deed may place property into a trust. However, if you are trying to claim homestead exemption as a beneficiary of a trust, we don't know if you have a title to the property or the real property under the trust agreement. So often our office does need to review those trust documents to grant a homestead exemption if you're not on the recorded title. Probate documents as well is not something that's delivered to our office. If you want to update your ownership and someone passed away, it goes through probate. There might be an order determining homestead or some other document that relates to the title of the property. Our office won't know about that unless you as the taxpayer provide that to us. So now we'll get through the more common forms of acquiring title to property. So the first one we're going to go through is a warranty deed. These are the more, one of the more common ones we see. The seller is essentially pledging or warrants to the buyer that they are the owner of the property, that there's no other outstanding issues on the title, that it's free from any, liens or other claims. The form for warranty deeds are set by statute. And if it doesn't comply with those statutory requirements, we do have abstractors on our staff that review every instrument that transfers title. And if something is missing or erroneous, you may receive a letter from our office notifying you that there is an issue with your deed that may need to be addressed. Even if we are able to update the ownership, it's more of a courtesy to allow you to correct that issue so it doesn't cause you title problems down the road. Quit claim deeds. These are often what we see as the do-it-yourself deeds that we get. They relinquish the seller's interest, even if they don't have any interest, to the buyer. They're not warranting anything like a warranty deed, and oftentimes we see these as like forms that people printed off the internet, then they hand fill these in to defect their title. But they can also have useful purposes when someone may not know if they have an interest, or if you're trying to clear up the title, you may get a quit claim deed done. But there are a lot of different reasons to use them, but they are often seen, at least from our office's standpoint, as the do-it-yourself deeds. Corrective instruments. This is the next one we're going to get into. So a corrective instrument is filed to correct something on a previous instrument. They can only be used to correct minor errors. So what is a minor error? Well, it can be a legal description error. It can be a misspelling of a name. It could be, a date that was conflicting with another date in the deed. However, the one thing it cannot do is change the tenancy. And this is very important for homestead purposes. So if you took property as tenants in common, which is the kind of standard tenancy, and we'll get into the tenancies a little more in a bit, but then you had intended to take it with survivorship rights. Well, you cannot do a corrective instrument and have it relate back to the original instrument. So the big thing about corrective instruments is if they're properly done and executed, they run parallel to the original instrument that it's correcting. And so they take on the date of the original one. And as I was talking about earlier, that January 1st, assessment date is important, and a corrective instrument can relate back to that original date prior to January 1st, but it cannot change the tenancy. So how do you change the tenancy? Well, the only way for our office's purpose of retroactively changing tenancy is through legal action. And so what we have seen in the past few years, much more, I'd say about 7 or 8 of them have actually come in the past 2 years, is what's known as a reformation action. And so what happens is the parties that took title improperly basically petition the court and say that we made a mistake on this original drafted instrument, and because we made a mistake, we would like the court to retroactively fix this. And really the biggest benefit that we see to these, at least on our end for property taxes, is someone may not qualify for the homestead exemption, or inadvertently took themselves off the title when they were trying to, put a child on title, and they took themselves off. And now that they're no longer in the title, they lose their homestead exemption. And because they lost their homestead exemption and it's past January 1st, we can't retroactively put it back on absent some type of corrective legal action. And the most common one we've seen is through reformation. So now we're going to get into the types of tenancy, the most common ones, and how they relate to your property taxes. So the language of the deed or the instrument that gave you ownership of the property is what we're relying on for the tenancy. So there's several different types. You have your common, basic sole ownership. You're the only owner of the property. You own 100% of it. We have tenants in common, which is when there's multiple owners on the property and you own it, in different percentages. You have your joint tenants with rights to survivorship, where you all own the property 100%. And in the event one of those joint tenants passes away, their interest is absorbed by the other joint tenants. Tenants by the entireties operates the same as survivorship, but it's only between spouses. You have trust ownership, and then you have life estates, which are someone can reserve the use of the property during their lifetime or for another's lifetime. And when that person passes away, the measuring life, the property transfers to someone else. And then you can have a combination of different types of ownership. So we'll get into them a little bit more. So tenants in common is what, like I said, it's when there's two or more people that have ownership interests. They can be equal or unequal. So in this example here, we have 50-50 or 20-80% ownership. However, you can have even weirder percentages. We've seen deeds come through where one person retains a 1% interest in it. A tenant in common can sell their interest in the property without joinder of the other tenant in common. What this means is that if you're a married couple and you have property as tenants by the entirety, you can't sell it without the other spouse signing off on it. While tenant in common, you can sell your percentage. Also, tenants in common is the default tenancy in Florida. So if your deed is silent to the tenancy or marital status, it is presumed that you intended to take the property as tenants in common. So what this means for your property taxes? Well, for homestead, you can only claim a homestead exemption on the proportion of the property that you own. So if you own 50% of the property as a tenant in common, you can only claim homestead on 50% of the property. And this can be an issue because in Florida, the homestead limits your increase in value to 3% or the consumer price index, whichever is lower. But the other half of the property in this scenario is not homesteaded. So that one can increase at a 10% cap per year, which is the non-homestead cap. And so it can result in having higher taxes because you're a tenant in common and you only have homestead on a portion of the property. So now we'll get into the other type of tenancy, or another one of them, the joint tenants with rights to survivorship. So this is another one that the form is set by statute, and the language on the deed must have survivorship rights on it. So if it just says joint tenants and doesn't mention survivorship, that does not give you a joint tenancy with rights to survivorship. It must say it has survivorship rights. And this is important because for homestead, once again, if you're a joint tenant with rights to survivorship, you can claim 100% of the homestead exemption as opposed to 50% or less, depending on how many tenants in common there were. And upon the death of one of the joint tenants, the ownership, it goes to the remaining tenants. If a joint tenant sells their interest without the joinder of the other joint tenants, then it reverts to a tenancy in common. So if there's three joint tenants with rights to survivorship and one of them sells their interest, they can sell 33%, but the rest of the joint tenancy is effectively severed. And so this can affect you if there's three joint tenants, you're the one claiming homestead exemption at 100%, and one of the other joint tenants sells without your joinder, now your homestead is reduced to your 33%. So it's just something to be, yes. Then it's presumed to be a tenancy in common and it would have to go through probate. So, if you don't have survivorship rights, then it would have to go through probate to transfer that interest. And Oh, yes. So on the face of the deed. So when you took title to the property, and the question was, how do you know what tenancy you have? So what you want to do is when you bought the property, generally your title company will give you a form ahead of time. Now they're all going to operate a little bit different. I'm generalizing here, but they'll give you a form and you'll check a box that says, I want to take this as joint tenancy right survivorship. I want to take this as a sole owner. But after that's all said and done, if you have a copy of that deed, it will say on there the type of tenancy that you have. So it'll say, the the grantor, which is the seller, transfers all their interest to the grantee, which is you, the buyer, and then below that, it will generate, right next to it, it will say what type of ownership you have. And so if you look on the screen, you can see here, this is an example of survivorship. So it says, between the grantor here and Karen and Harold, joint tenants with full rights of survivorship. So that's how you know it's a joint tenant of right of survivorship, because it says it directly on the deed there. So that's what you're looking for if you want to know the type of tenancy that you have. And then we'll get into tenancy by the entirety. So this is reserved for only people who are married. And it is severed upon divorce. So once divorce is finalized, you instantly become tenants in common, where you own the property at equal percentages, unless something different is stated on the deed, or the divorce acted as a conveyance to one of the other spouses. So now we'll get into trusts and homestead. So a lot of people, usually for estate planning purposes, may place the property in a trust. For your taxes, this is important because depending on the type of ownership you have, you may or may not be able to claim homestead exemption. When the property goes into a trust, if you're not the trustee of the trust, you're the beneficiary of the trust, you may no longer be entitled to homestead exemption unless there's specific language in your trust that allows you as the beneficiary to claim homestead. So we'll get into kind of some basic trust terminology, so no one's really lost here. But so a trust is a device for property management in which a trustee manages assets as the fiduciary for beneficiaries of property that's placed in the trust. The settlor is the person that creates the trust. The settlor can also be a trustee or a beneficiary of the trust, but they are the one that created it. The trustee has legal title to any real property placed in the trust and manages it for the benefit of the beneficiary. The beneficiary is the person that the trust is for the benefit of, and they hold a beneficial interest in the property in that they benefit from the trust. And they also, under most trust agreements, have the power to enforce the trust, if the trustee is not administering it. So then we're going to get the last two. These are actually other ownership information. This is about a life tenant and remainderman. So for life estates, the life tenant is the person who has possession of the control of the property during their lifetime. The remainderman is the person that the property goes to after the life tenant passes away. So these are the requirements for a beneficiary under a trust to claim homestead exemption. So the beneficiary must have an interest in the real property, not personal property. And this is a very important distinction because there are what's known as land trusts, which are common in Florida, where the trustee holds full legal and beneficial title, and the beneficiary of that land trust has an interest in the income or proceeds of the trust. So the trustee manages the property, it makes money, and the beneficiary is entitled to that money, essentially. The issue there is that's considered a personal property interest, not a real property interest, and would disqualify them from homestead. So the other ones, the applicant has to have the right to live there. So as the beneficiary, you have to have the right to reside on the real property. And it must be a present possessory interest. So you may be a beneficiary of a trust, but your interest may not vest until someone passes away. And so that would be a future interest as opposed to a present interest. You need to have the present interest in the now to reside on that property. The deed transferring the property into the trust also needs to be recorded as well. That is a requirement. So right here, we have some sample language from a trust that we, like to show, because this is language that would grant a beneficiary the interest in order to claim homestead if it was either on the face of a deed, grantor, who's putting the property into the trust, reserves the right to reside on the real property as his or her permanent residence during his or her lifetime. That's what we're looking for a beneficiary to claim homestead. So now we'll get into life estates. So it is an estate or type of ownership for the duration of an individual's life. During that time period, they generally have the right to use the property, subject to the life estate and remainder, or to mortgage it. And then once they die, the estate ends and it goes to the remainderman. If there is no remainderman, it reverts back to their estate. So the remainderman cannot claim homestead exemption. It's another thing. You have to have that present possessory interest. And because it's a future interest, they cannot claim homestead if you're the remainderman to a life estate. So we'll get into some terminology. This is something a sample to look for to know if you have a life estate. So it may say as to a life estate, or reserving unto themselves a life estate, or for during their lifetime. And below this are what are called enhanced life estates, or more commonly, a ladybird deed. You may have heard this term before. What a ladybird deed or enhanced life estate does is the life tenant can still sell the property or change remaindermen prior to their death. And so it's a very common estate planning tool because it allows the life tenant to still manage the property, or if they need to sell it, or if they want to give it to their son instead of their daughter, they can change the remaindermen prior to their death. But then upon their death, there's nothing they can do. It goes to who the current remainderman is. So cap resets, and we had some questions about this prior to the presentation, and we'll get into these. But in Florida, there's two different types of caps. The first one is the Save Our Homes cap, and it was introduced in a constitutional amendment in 1992 from the Lee County Property Appraiser. It limits the increase of assessed value for homesteaded property to the lesser of 3% or the percentage change in CPI. Past few years, the CPI has been over 3%, so it's been capped at that 3% increase. This was designed to protect people from being taxed out of their homes by a rising market, real estate market. So the difference between your just/market value and your assessed value is what is known as your Save Our Homes cap benefit. And that Save Our Homes cap benefit is something that you can take with you in Florida if you do end up purchasing another home somewhere else. So the second cap is the non-homestead 10% cap. This is another constitutional amendment approved by voters in 2008. And it created a cap on any non-homestead property of 10%. So any property that does not have homestead gets the 10% cap. Now, if you do homestead property that had a 10% cap, the 10% cap goes away and the homestead begins. So you can only benefit from one status or the other. You either have homestead or you have the non-homestead. You can't roll the non-homestead cap into your homestead. And the cap remains every single year as long as the ownership does not change or it changes status from non-homestead to homestead, or there was no split or combination or new construction. New construction will go over the cap. So here's the kind of a list of the CPI versus the cap each year. You can see that in 23 and 22, the CPI was well over 3%, so it was at a 3% cap that year. The only other year we had hit that limit was in 2012 previously. So here's kind of a cap comparison between the two. So the kind of the one of the big benefits of the Save Our Homes homestead cap is that it can actually be transferred to another property that you purchase within the state of Florida. And after you sell your current home, you have a 3 tax year window to apply for and be approved for the portability at the new home. If you wait beyond 3 years, then you lose out. And that window used to be 2 years, and actually from legislation championed by Mr. Twitty, it was increased to 3 years because sometimes that 2-year portability was actually 1 year and a month. So it helps out people who are selling and maybe taking a little time to move into a new house. It limits to 3% versus the 10%. And the Save Our Homes cap requires homestead versus the non-homestead cap does not. So there are some exceptions to when these caps reset. The first two, they largely mirror each other, the resets on the Save Our Homes cap versus the non-homestead cap. But the first one is to correct an error. So, if you're correcting, but remember, as we discussed earlier in corrective instruments, correcting an error does not mean tenancy. Even if it was an error, that's only something that can be corrected through legal action. Correcting an error could mean correcting a legal description or correcting a name that prevented the property from transferring previously. The second one is the transfer between legal and equitable title. And so the way our office interprets this is when you put property into a trust, you are now transferring between legal and equitable title. So the beneficiary has the equitable title and the trustee has legal title. So when the property is placed into the trust, it does not reset your Save Our Homes cap or non-homestead 10% cap, so long as the original owner has either legal or equitable title to the property. For the Save Our Homes, if you add a new person to the title, it's not going to reset your Save Our Homes cap or homestead exemption unless that new person applies for an exemption on the property. On the non-homestead side, a cumulative transfer of more than 50% of ownership through the public stock exchange. So that we don't see that very often, but that doesn't trigger a reset. The Save Our Homes cap doesn't reset as an operation of law to the surviving spouse or minor children. So if a spouse who claims homestead dies and their property goes to the spouse or a minor child, it does not reset. And also a transfer to a legal dependent. And a legal dependent is more than just claiming someone on your IRS income tax return as a dependent. They have to be their legal they have to be a legal dependent, meaning you may have to be a guardian or some other type of arrangement over that person. And then also a transfer between husband and wife during or immediately following a divorce does not trigger a reassessment. So this is this is a case that recently came out about the non-homestead cap that is very important to review because it clears up kind of a common misunderstanding as to an exception for the reassessment for non-homestead purposes. So if property transfers from a person to an LLC or a married couple to an LLC or from an LLC out of it, the cap is reset. It doesn't matter if it's a sole member LLC or 2 members of the LLC and it's moving, from them to the LLC that they own or out of it, it still is reassessed. And this case out of the 3rd DCA found in favor of the Miami-Dade property appraiser. And essentially, the third DCA held that the transfer from individuals to an LLC, the members do not have equitable, legal, or beneficial title to the property that's now owned by the LLC. The members of an LLC don't have any specific interest in the real property anymore, and therefore the non-homestead cap gets reassessed. So we'll work our way into marriage and homestead now. So for homestead, you're allowed one homestead exemption per individual or family unit. Well, what is a family unit? The courts have defined it as a married couple. There's been, several cases discussing what a family unit is, and more or less it's an intact married couple is what is considered a family unit. And so what is an intact married couple? That requires kind of a complicated determination by our office and any property appraiser that may need to do this, but there's two criteria to it. Whether or not you're in an intact marriage for the homestead exemption is determined by seeing if the finances are separate, or if in addition to that, if the marriage is no longer congenial. So kind of a weird standard, but we have to determine that if a married couple is attempting to claim two different homestead exemptions. So what that means is if you're in an intact marriage and you're claiming homestead exemption, you only get one homestead exemption. So what we see a lot of times for people that may get married later in life, and both people are established, they may have their own homes, and they each may have their own homestead exemption. Well, when you get married, you need to notify our office so we can remove one of the two exemptions, and our office can assist you in determining which exemption will save you more money than the other when deciding which one to remove. So exemptions from public record, also known as protected names for our office. So if you own property in Florida, and you may be able to have your name redacted from the public record if you belong to a class of people. So victims of violent crime, law enforcement, generally a lot of the government agencies are that may have dangerous jobs are included on this list. And so you can have your name protected from public record. Your address will still reflect, and parcel number will still reflect on our website, but your name will not be associated in any way with that property. In order to do so, you do need to apply in writing to our office and any other government office that you may want to have your information protected from. So if you apply for our office, you will have your name protected from the property appraiser's records and the tax collector's records. You would need to separately apply through the clerk of the court or the supervisor elections if you do want to have your voters' information and your name off of any deed or anything that may be recorded. So this is what it'll look like on our website if your name is protected. You can see your owner name, your instrument where you took the property is protected, the grantor and the grantee, elevation certificates, permits, those are all pulled off of the site. Any transfer of ownership will trigger the removal of this, and also title insurance agencies and attorneys in good standing may still request protected name information from our records. So now we'll get into some recent legislation that came through. So there were a record number of ad valorem related bills, about 30 bills, 6 of them passed, and 8 in the tax there were 8 issues in the tax package that came through. We're going to talk through kind of the most relevant ones here. So verification of eligibility of homestead exemption. This is House Bill 1161. What this bill is doing is allowing for a pre-qualification letter from our office for 100% total and permanent veterans and their surviving spouses. And the reason behind this bill was primarily when veterans were getting a mortgage, they need to take into account that they're not going to be paying any taxes on that property, but the mortgage company wouldn't know that until they had purchased it, because you then have to apply for the exemption, and you can't apply for the exemption unless you own the property. So now they can provide us information, and we will offer a pre-approval letter to those 100% totally and permanent disabled veterans or their spouses, surviving spouses. So there is the annual adjustment to the homestead exemption value. So the homestead is broken down into two exemptions. The first 25,000, which comes off all of your levy taxes. Then a second 25,000 that is comes off all of your other taxes except for the school districts. This bill would increase the second exemption by the CPI change each year. It will require a constitutional amendment, and it will be on the November 2024 ballot to be voted on. And I believe it needs a 60% approval to go into effect. So the other one, this is found in the tax package. This is important in Florida for storm damage. So the time period to commence repair or rebuilding of homestead property after damage or destruction has been extended from 3 years to 5 years. So what this does is, in Florida, if your home is damaged or destroyed by some type of catastrophe, and you rebuild the property, your improvement will not go over your Save Our Homes cap. However, you had 3 years to commence these repairs and pull permits after the damage. Well, now it has been extended out to 5 years. And this will be effective the 2025 tax roll. So a couple, one that didn't pass. So all online listings of residential property visible on public-facing real property listing platform, including, so this was the bill that our office had put forward, requiring a more accurate estimate of taxes on real estate websites. And what this bill was aimed to do was address misleading folks who are attempting to buy a property and the seller's taxes are listed on the website. The seller may have had homestead for 10 or 15 years, limiting their taxes substantially, and a buyer relying on this purchases a property, sees their taxes based off of the market value of the home, which can be a real shock to some people when they see, what they thought was a $1,500 tax bill go to maybe $6,000 the following year after purchase. The bill did not pass. Well, we do have a new website now. So we are now pcpao.gov. It is official. We're no longer .org. That website is inactive. Please go to the .gov website. It has some wonderful information on there, and it's really user-friendly. I highly encourage anyone watching this to please go and check it out. It's wonderful, especially for real estate professionals. You can get info very, very easily. And this, based on our statistics, the heaviest users are property owners, purchasers, and real estate professionals. So I'll go over some stats. You can see we have 1.8 million users in 2023, with 5.2 million sessions and 51 million page views. It's a lot. Still a lot of people using it on the desktop. But although our new website is mobile friendly, so we encourage you to check it out on phones as well. So the tax estimator, this is a new feature, and it is wonderful. So if you are interested in purchasing a home, you can access our tax estimator on our website to get a fairly accurate value of what your taxes will be the year after your purchase. And so you will navigate on the tools and forms and data on our website. There's a lot of ways to get there. Even if you're just looking at the property on our website, you can also go to the tools and access the tax estimator as well. So what you'll do once you're on the tax estimator is enter, if you got there from the parcel, then it'll auto fill it. If you go there from the home page, you can type in the address, and then you're going to type in your estimated purchase price. And if you plan on homesteading the property or transferring the homestead from somewhere else. So this will calculate your taxes the following year, even with your homestead and portability applied to it. It's a wonderful tool. And then this page is what it's going to look like when it comes out. It'll show your estimated assessed value, and then your estimated ad valorem taxes down there at the bottom. And that'll give you a much more accurate idea of what your taxes are going to be than if you were just looking on a real estate site that may be using the seller's taxes. And then a couple additional things. We do have a buyer and seller fact sheet available. These are available on our website as well, and you can email them, print them out. They're going to, explain to you your portability benefits, your time limits to do so. It's going to, offer you advice on the estimate of your taxes, how to apply for homestead, really everything you're going to need to know from property tax standpoint for buying or selling a home in Pinellas. So we encourage you all to stay in contact with us and sign up for any of these other lunch and learns that we do. You can follow us on Facebook. This will be put on YouTube as well, or you can always come in and attend in person, although maybe not today because it is coming down out there at the moment. So our upcoming programs, we'll have one on personal exemptions coming up soon. And then, the property taxes for business, real estate professionals, and first-time home buyers will be the last one in the queue. We run these on a loop every year. And the final thing, and possibly one of the most important things as well, is the free property fraud alert service offered by the clerk of the court. What this does is you sign up with this service for free. You enter in your name and a contact information, and even your property, and anything that gets recorded in your name, the clerk will contact you and allow you to review that document to determine if it is legitimate or not. It's a wonderful service, and it's completely free, and I highly recommend anybody to sign up for it if you haven't already. So thank you all for your time, and I look forward to you all being there on our next Lunch and Learn. Thank you. Oh, and if we have any questions, all right, thank you, everyone.